Hello, welcome back viewers. Welcome back to my channel. My name is Tawia Matope. This is the channel where I do deliver content in regards to social work practice, especially practice with children and families. If you are new to this channel, I would encourage you to subscribe to the channel and also like the videos that you are watching, as well as click that notification bell so that whenever I post videos, you'll be the first person to be notified of the videos that I'm going to be posting to this channel. Thank you so much for tuning in today. And today I'm going to be talking to you about one of the most important topics in social work practice or in safeguarding work with children, especially for social workers who are working in safeguarding work. And this might be of interest to you if you're a social worker or a social work student, or if you're even a parent who is just interested of knowing the work that social workers do. So the topic I'm going to be talking to you about today is with regards to the public law outline or the PLO process. I'm going to be talking you through what the PLO process is, what it entails, and also what would be the possible outcomes of pre-proceedings work when you are engaging with social workers or when social workers are engaging with families. So with regards to the public law outline, this is the process that local authorities or the mandate that local authorities have when they are having significant concerns about the welfare and the lived experience of a particular child, and where they are concerned that the child is continuing to suffer significant harm of significant risk of harm. And so what happens is usually when we are escalating a case to what we call PLO process, usually the child would have been subject to a child protection plan, but sometimes it's possible that the case can escalate while it's on the child in need plan straight to the PLO process, or what we call the pre-proceedings. So this is the process that the local authorities take, or the last stage that parents are given before a case goes to court, to say this is the last the last option, or the last stage that we are trying to engage with you before we actually take this case before the courts. However, a decision to enter pre-proceedings is made by the service manager or the head of service, or sometimes the strategic lead of the particular local authority. And in some cases, threshold would have been made to go to court, but there is an understanding that we need to give these parents another last chance to work with the local authority before we take this case before the courts. So the PLO process actually sets out, several rules which social workers or local authorities need to adhere to when it comes to the local authority thinking of making an application to court in respect of particular children. So for me, just to obviously put a disclaimer, I always want to put a disclaimer. I'm not claiming to be a guru when it comes to safeguarding work, but this is information that I'm sharing in terms of my own practice experiences, managing social workers, as well as, being a social worker myself, and sometimes, for my own self-directed learning. And I have got a passion of sharing the information that I know with others, and I'm hoping that it will be helpful to somebody out there. Right, so the PLO process basically is where the local authority wants to actually to give the parents or the carers of a particular child the last chance before the case goes to court, and it gives an opportunity for the parents to access legal support, or to access to actually have solicitors in their corner to better understand the concerns of the local authority, and to be able to have that, those series of meetings that are held within the pre-proceedings process, to better understand what are the concerns of the local authority and what needs to be done for the family, for actually for the case not to go to court, or for the case not to spill to end up being in the court arena. Right. So with regards to the PLO process, what usually happens would be if a social worker is concerned about particular children, they will have a conversation with their manager, and the manager will have a conversation with the service manager or the operational lead, depending with the setup of a particular local authority. But in some local authorities, it is possible that a three-way meeting could be held between the social worker, the team manager, and the service manager, or the head of service, whatever designation is given. But another manager who is responsible for the safeguarding team to make a decision as to whether threshold has been met to enter the pre-proceedings meeting. So this is just a preliminary meeting that is held between those three professionals. However, there is what we call a legal planning meeting that will need to be held before, a legal planning meeting, where basically the local authority will be seeking legal advice from its solicitors as to what exactly needs to be happening with regards to those particular children. And in terms of seeking legal advice, they'll be seeking legal advice to determine whether threshold has been met to go to court. So in some circumstances or in some situations, threshold may have been met, or the solicitors may have advised the local authority threshold has been made to go to court, but a decision is made by the head of service or whoever is designated to make that decision to say, okay, fine, we have made threshold to go to court, but let's give these parents the last chance to work with the local authority under what we call pre-proceedings, the pre-proceedings process. So what happens is within that legal planning meeting, if a decision has been made that we need to enter what we call the pre-proceedings, there is what we call a letter before proceedings that needs to be completed by the social worker within, I would say, 2 days of that particular meeting being held. And when this letter before proceedings is written, it's quality assured by the manager, and sometimes it's sent to the head of service just for further quality assurance before it is served to the parents. And once that letter is served to the parents, it depends whether the parents are presenting as a couple or they're presenting as individuals. Maybe they are no longer together. Even if they are together, there are sometimes they've got the right to present as separate in that particular meeting. So once they receive that letter before proceedings, it automatically entitles them to what we call legal aid, which means basically they need to be taking that letter to the solicitors as soon as possible. The letter would actually come with, letter, please take this to the solicitor now, and do not wait or do not delay. Within this pre-proceedings letter or letter before pre-proceedings, it clearly stipulates what are the concerns of the local authority, what support has been put in place by the local authority at that particular stage. Usually, sometimes the child will be subject to its child protection plan, and there would be other support agencies who may be working with that particular family to try to address those concerns. So it stipulates the concerns of the local authority. Like I said, it also stipulates what work has been done with that particular family. It also stipulates what needs to be done for the local authority not to proceed to go to court with regards to those particular child or those particular children. With regards to parents receiving that letter, they need to take that letter immediately to a solicitor of their choice. Usually that letter comes with what we call a pre-proceedings pack. Sometimes it contains the list of solicitors within the local area who specialize in children and family courts, and they will choose a solicitor of their choice. Sometimes if they've got a solicitor of their choice already who may be conversant with children and family matters, they can approach their own solicitor, but it usually comes with a list of solicitors. And in that pack also, sometimes there is a 1-minute explanation of what the PLO process is exactly, which helps to explain to the parents what's going to be happening. All right. So within that letter as well, it clearly stipulates what we call an initial PLO meeting that would need to be held, where the parents would need to attend with their solicitor. So it is really, really imperative that when a parent receives that letter, they need to seek legal advice as soon as possible, and they need to consult with their solicitor before even coming to that meeting. And when they come to that meeting, they need to make sure that they come with their solicitor. There are sometimes parents where they will rock up to the PLO meeting on their own and they demand to proceed with the meeting on their own, but it needs to be recorded clearly that the parents have made the choice not to be represented. So by virtue of having that letter, they are not meant to be paying for the consultation which they are making to this solicitor, as everything will be paid, by virtue of, the local authority serving that letter to them. It entitles them to go and seek legal advice from any solicitor of their choice. So the question is, I spoke about what we call the pre-proceedings meeting. So what is a pre-proceedings meeting? This meeting is meant to discuss what needs to be done for the local authority not to proceed to go to court with that particular child or with those particular children. It also clearly stipulates what needs to be done to protect that child from further harm, and it will also agree on what plan that needs to be put in place to reduce the risks to that particular child. So you'll find that within this PLO process, or within this pre-proceedings meeting, you will come up with a plan that you will agree on what needs to be done going forward to avoid the case going to court. But this plan usually also incorporates what is in the child protection plan already. It is incorporated into that PLO plan, so that going forward everything will be synchronized. So some of the things that that local authorities might be looking at doing before taking that case to court, it's more to do with preparatory work, really. If that work is done, well, and sometimes the parents do engage well, they make the changes that are expected, there are two possible outcomes from a PLO process, from the PLO process. One, maybe changes have been made, but they are not really they are not really at what was an expected level. So it's possible that the PLO process might be extended with a further maybe three months or something like, or with a further 6 weeks or something like that, to make sure that all the work is completed, or all the assessments which have been ordered are completed. So in terms of the timescales, the PLO process should be completed within 12 weeks. 12 weeks, if you translate it, it's just 3 months. So there's no time. Time is of essence, and there shouldn't be any drift or a delay when it comes to the PLO process, right? So within that PLO plan, or the things that will be agreed in the PLO meeting, one, it could be, for example, referral to the FGC, Family Group Conference, or it could be that a parenting assessment needs to be done, or it could be that a psychological assessment needs to be done, either on one of the parents or both of them, or maybe on one of the children, to better understand what is going on and actually better understand how best they can be supported going forward. There are other also assessments that may be undertaken within the PLO process. There are a wide range of assessments that can be undertaken within the PLO process to better understand what is actually going on with regards to those parents. And there are also other tests that could be ordered within the PLO process, including DNA tests, sometimes including a strand test or a blood test to determine whether or to determine the level of substance use with regards to one or both of the parents. So a strand test could be done, or a blood test could be done to determine whether, how concerned are we with regards to use of substances with regards to either one or both of the parents. Right, so within that, I spoke about the letter which is called the letter before the letter before proceedings. So I think I've emphasized already that the parent needs to be taking that letter immediately to a solicitor of their choice, and have consultation with that solicitor, and be able to actually bring that solicitor to that initial meeting that is attended. So within that pre-proceedings meeting, who attends that meeting? So I mentioned about the parents, I mentioned about their solicitor. So for example, if two parents are no longer together, the mother and their solicitor will have their own individual meeting. The father with their own solicitor will have their own individual meeting. If there are 3 fathers, it means each and every one of those fathers will have their own individual meeting with regards to their own particular child. Because remember, the parent who has got parental responsibility is the one entitled to be attending that particular meeting. So if, for example, we've got a mother who has got 3 children, and all 3 children are holding SNM, the fathers don't have parental responsibility, we may only focus with that particular mother. So sometimes within that PLO process, if the mother indicates that they should want the fathers of these children to be involved, that's when we can talk about including those fathers, and also having those, DNA tests done to confirm that they are the fathers, so that if ever there is an eventuality that this case spills into the courts, we have already identified the fathers. So I spoke earlier on about who attends the meeting, but before I come back to who attends the meeting, I just wanted to outline the possible outcomes of the PLO process. Like I said earlier on, the possibility is that the PLO process might be extended to further ascertain other things that may need to be ascertained with regards to the assessments being carried out, or the PLO process is ended and we go back to the child protection plan, or sometimes the third outcome is we may say, okay, fine, we've done the pre-proceedings, things are still not working, we are still concerned about this particular child or these children, they are still at risk of significant harm, they continue to be at risk of significant harm, then we need to be going to the court. So when we spill into the courts after the pre-proceedings, the local authority has already gathered evidence that is going to be presented in court in terms of what has happened before the pre-proceedings, what has happened in the pre-proceedings, and then the case is being taken to court. So those are the three crucial outcomes of the PLO process. Then coming on to who attends the pre-proceedings meetings, I mentioned about the parent and their solicitor. The social worker will also attend. They will be the one to present the case. In the absence of the social worker, whether they are ill or they are not at work on that particular day, the team manager will need to be presenting the case. In that instance, then it means the service manager or the operational lead or the head of service will need to be chairing that meeting. So basically, the parent, the solicitor, the social worker, and the team manager. Usually, team managers do chair PLO meetings. It depends from one local authority to the other. In some local authorities, it's service managers who chair, but in the local authorities where I've worked, team managers do chair PLO meetings or pre-proceedings meetings. Right. I've already mentioned about who attends the meetings. So it's really, really crucial that parents do attend their PLO meetings. These are meetings for the parents. Children, or the PLO meetings that I've done, I haven't seen children attending, but it's meant for the parent who is having parental responsibility over that particular child. Right, so in terms of what happens at the PLO meeting, I think I've already explained this one. Basically, the social worker outlines what are the concerns of the local authority, what work has been done to support this family to address these concerns, what has happened, for us to not reach where we felt it needed to be. And the social worker also have a chance to explain what needs to be happening going forward for us to avoid, the situation where we end up going to court. So this meeting is really, really crucial. But one thing I'm going to emphasize is the fact that the PLO process itself, or the pre-proceedings process, is meant to be a supportive process. If there are other things that the parents think or they may need to identify that hasn't been done, but they think it needs to be done to avoid going to court, this is the opportunity that the parents have to be able to articulate those issues and make sure that they get the support that they need. Remember, this is meant to be a supportive process, and it's not meant to be a persecutory process, because nobody's there to persecute the parents, but we are there to support the parents. All right, so that is basically what happens in a pre-proceedings meeting. So if the local authority decides to proceed to go to court and initiate care proceedings, then we are entering proceedings, and that process in terms of the care proceedings is meant to be done within 26 weeks. So if the PLO process has been done properly and some assessments have already been done, but they still felt that there is a need to spill into the courts arena, it means it reduces the time, the 26 weeks, because some of the assessments which should have been done within the court arena would have been done within pre-proceedings. It means, for example, the parenting assessment has been done already, unless if the parents are disputing it and they would want an independent social worker to actually do it, then yes, that, it depends. It's up to the judge to read that parenting assessment and decide whether there's need for an independent social worker to actually be undertaking another updated assessment or a new assessment altogether. So when it comes to the assessments being done within PLO, if there's a decision that a cognitive psychological assessment needs to be done or a normal psychological assessment to be done, obviously a psychologist is commissioned or if the local authority employs one, that person will be able to do that particular assessment. However, if it is felt that a parenting assessment needs to be done, the allocated social worker to those children will be the one to progress that parenting assessment, mainly because they know that child much better than anybody else who is going to be contracted to come and undertake that parenting assessment. So that's basically the PLO process. I think I've articulated what the PLO process is, or the pre-processing process is. What happens before the before the PLO meeting, and what happens during the PLO meeting, and who attends the PLO meeting. So with those few words, I hope this has given clarity to somebody. If you've got any questions or anything else to ask, please let me know. If I need to do another follow-up video to better explain this process, I'll be able to do that. If there's something that you feel has been left out, please comment in the comment section below. And thank you so much for watching. And please subscribe and hit that like bell, and also hit that like button, and also hit that notification bell, so that when I post another video, you'll be the first to know, and you'll be able to watch and share with your other colleagues or family members. Thank you so much.